Forward and proceed whenever you're ready.
Seems I know how to clear a room. Thank you, Mr. Chair and esteemed committee members. For the record, I am State Representative Brian Seitz, and I serve the 156th District. House Joint Resolution 129 is a resolution that deals with a sensitive subject that needs public recognition and acknowledgement that, in fact, it exists. The decades past of shaming victims, hiding abuse, and turning a blind eye is soon over, and this legislation represents Missouri's beginning to help victims and to hold account perpetrators and those whose tortious conduct allowed these horrors to continue. The Missouri Constitution currently prohibits laws retrospective in their application. One type of law this applies to is reviving an expired statute of limitation. Upon voter approval, this resolution amends the provision to allow civil actions filed by victims of certain sexual offenses or childhood sexual abuse to file causes of action at any time against perpetrators of the abuse or those whose tortious conduct caused the person to be a victim of a certain sexual offense or child sexual abuse. 21 states have no civil statute of limitations for child sexual abuse. Missouri is called the Show Me State. And via this committee hearing, we are going to show you the absolute necessity and moral imperative behind passing this through your committee, getting it to the House floor and the Senate, then to the general public who will support it wholeheartedly because it's the right thing to do. My House Bill 1617 and last year's House Bill 367 dealing with increasing the statute of limitations for childhood sexual abuse has never had a no vote. Never in 2 years, including last year's 154-0 on the House floor vote last year. But powerful lobbies continue to scare and cower legislators in both the House and Senate with paper tigers and boogeymen. Today's legislation should put the fear of God into those corporate lobbyists. I'm now going to say the words: rape, forcible sodomy, trauma, abuse, and now I'm going to say the word children. Let these words never be put together again in the state of Missouri, beginning today, beginning now. I'll open myself up for questions, keeping in mind that there are witnesses behind me whose voices need to be heard. I ask that you treat the victims with kindness and respect, as I'm sure you will. I'll now take any questions.
Any questions from the committee? Seeing none, thank you, Representative, for the presentation. First witness in support, please come forward.
Chairman and committee members, my name is Catherine Robb. I am the Executive Director of Child U.S. Advocacy. I am testifying in support of HJR 129 that amends Section 13 of Article 1 of the Missouri Constitution, eliminating the statute of limitations with revival only as to child sexual abuse crimes. This amendment is a very simple and narrow change, and it protects children. The data indicates that 1 in 5 girls will be sexually assaulted before their 18th birthday, and 1 in 13 boys will be sexually assaulted before their 18th birthday. Who are the perpetrators? Coaches, camp counselors, teachers, clergy, family, doctors. Most predators are someone the child knows, their family knows, and at one time perhaps loved and trusted. Most predators have hundreds of victims. Victims suffer in silence because of the trauma of this type of abuse that is particularly dangerous to the developing mind of children. I could go into a lot of neurology now, but I'm not sure I have the time. But trust me, that it affects the architectural structure of the mind of a child. It causes depression, anxiety, post-traumatic stress, eating issues, sleeping issues, educational issues, memory issues. The list goes on and on. This epidemic is ubiquitous, affecting children from every part of society, in all religions, in every single political party, in all races, all socioeconomic backgrounds. Every single child is in danger. The average age a victim comes forward is somewhere between age 50 and 70. Most come forward when their own child is the age that they were when they were abused. Many, and I've heard countless stories across the country about survivors, come forward when their parents die because they don't want to upset their parents. The cost to society is staggering. The effects of child sexual abuse not only weigh heavily on the victim and the victim's family, but it also and most significantly on Missouri taxpayers as trauma reaches far and wide, burdening many, many sectors of society, the educational system, medical health system, mental health services, social services, the work sector, law enforcement, and finally, the penal institution. This bill is part of a much larger national movement. We have 30 jurisdictions thus far that have passed revival legislation, 27 states, and 3 U.S. territories. I've testified in all of them. 21 jurisdictions and the federal government, thanks to Senator Dick Durbin in the Judiciary Committee, passed the No Time Limits for Act. So lawmakers across the country, at the federal level and at the state level, are responding to this epidemic of child sexual abuse. Statute of limitation reform serves 3 public objectives. It educates the public, parents, teachers, grandparents, and people that care about children about this epidemic. It shifts the cost of abuse away from the victims and their families and the taxpayers to the bad guys, where it belongs. It also, and I think most importantly, identifies hidden sexual predators. You may hear many what I would call the sky is falling fear-mongering. One is the courts will be flooded. At Child U.S. Advocacy, we have tracked all of the court filings in states that have passed revival legislation. And on average, the percentage of the population that go to court for these claims is 0.0002. So the courts are not flooded. The courts handle this just fine. You may also hear that businesses and schools may shut down. False. There's absolutely no reliable data on this, and it is hard for me to prove a negative. The vast majority of businesses and schools have insurance, and quite frankly, those businesses and schools and camps that do the right thing and care for children and report abuse hire good people, train good people, have good policies and procedures and responses, have nothing to fear. You may also hear that tort law, by its very nature, deals with terrible accidents, and some of them are catastrophic. I would like to be very clear here. These are not typical torts. This is not something I learned in law school. These are not fender bender claims or slip and fall cases. To be clear, we are talking about the rape, sodomy, and sexual assault of our children. You may also hear, well, statute of limitations has a purpose, encouraging prompt filings, allowing the best evidence to come forward. I believe in due process as an American. I believe in due process as an attorney. But due process is not absolute. I also believe in justice and protecting children and sound and reasonable public policy. Most of our laws, as you know better than most, have exceptions, and oftentimes those exceptions have exceptions to those exceptions. And those exceptions are based on sound public policy, justice, reason, and common sense. You don't need to be an attorney to understand this. SOLs are arbitrary time limits set by legislative bodies such as yours. We also have safeguards in place, the rules of civil procedure and the rules of evidence. Moreover, plaintiffs must prove their cases. They must survive a 12B motion to dismiss. And quite frankly, attorneys won't take weak cases. False claims are exceedingly rare. You may also hear, well, we don't need civil reform because we have our criminal system and that just works fine. Sadly, the vast majority of criminal cases for sexual assault and rape never move forward to prosecution, and few result in a conviction. And this means that 9 out of 10 sexual predators will walk free. And I ask you, when was the last time you saw an institution go to jail? Companies and organizations will do the right thing by children only when they know they can be held accountable in a court of law. That is the only time they can do that. We cannot allow them to be the fox watching the henhouse. The fear-mongering you may hear is all to protect deep and powerful pockets, not to protect children. And finally, I'd like to share, I'm a mother of 5 beautiful children. Last year, my oldest son, depicted here as an 8-year-old little boy, came to me.
Sorry, I'm going to have to interrupt. We don't allow props, so you can go ahead and tell the
that's
story,
fine.
but no props. Thank you.
That's fine. It's a photo of my son at 8 years of age in his Little League uniform. He came to me at age 31. He's my oldest child. I'm an expert, and I've been doing this work for over 20 years. And he came into my office, and he sat on my couch, and he said to me, Mom, do you remember that time you and Dad took me to the ER in Boston when I was sick with something? And I said, yeah, I do. And the doctor told us that he was taking our son for a test. But he took my son, my very sick, perfect, beautiful son, at age 8, down to the basement in a dark lit area and sodomized him. In the late 1990s, when my son was 8 years old, I did not know about this epidemic. I did not know I couldn't trust an ER doctor. I did not know about the data. I did not know about the hell of clergy abuse. I did not know about the abuses at Kennecott Camp here, or Jerry Sandusky at Penn State, or the Boy Scouts of America, or Larry Nassar, or Michael Jackson. I didn't know that. I didn't know I couldn't trust an ER doctor. And this is why there's a national movement now, because we know every day I receive news reports, every day all over this country, at least 10 a day about a new story, and sometimes you see them on the national news. And this is why there is a national movement to eliminate and revive statute of limitations, again, only for child sexual abuse claims. And I ask you, Why should sexual predators and other bad actors be protected by the passage of time when victims suffer in perpetuity? I hope that you can support this bill, and I'm happy to answer any questions. Thank you.
Any questions from the committee? Representative Hicks.
I want to preference this with I am in support of this bill here. And I have my own legislation that deals with the sex registry and protecting kids there. I honed in on a few things that you said. And being an attorney myself, I'm just curious and how this is working in other states. So if we open this back up and to go retrospect in this here, allowing these claims to go through, there is generally in law, as you know, a concern about evidence at a certain point there and how stale a case gets or how far you get detached from it and being able to prove it. You mentioned due process. I think due process is a very, very critical component of this here by itself. And I'm in favor of, if somebody has a claim, bring it forward. But obviously we fall under the American rule when you talk about civil actions usually where it's, unless it's specified in certain statutes, you can't get attorney's fees for it, even if like you brought the wrong case, it wasn't the right party, you couldn't survive a motion to dismiss, whatever it is at that point there. So I guess my question is more of is, with other sorts of states that have opened this up to kind of protect both sides, because I'm not saying one side has a claim and the other side doesn't, it's just let's let it play out in the courts, is if the party bringing it can't survive their motion to dismiss or whatever, they can't meet the burden or whatever it is, which do other states allow for attorney's fees in cases like this here, since we're kind of going retrospect, which is an area of law we standardly don't do things like this here from a law standpoint?
Thank you for your question. The answer is generally not, because folks don't bring these claims unless they're legit. And again, like I said, we have the rules of evidence, the rules of civil procedure. False claims are exceedingly rare.
Yeah, no, I'm
Yeah.
not saying false claims
So-
aren't rare, and
Right.
civil procedure, rules of evidence, those place certain things within the greater item of here of whatever you're filing in the lawsuit. I'm not saying they're frivolous claims per se. What I am saying is, would you be supportive of, if we do something that we standardly don't do in law like this here, that we maybe add something in there just out of curiosity that allows people to, if a court finds there's not a case or whatever it's dismissed on or whatever it is, that the other party is able to seek reasonable attorney's fees for essentially being kind of falsely accused, since we're kind of opening this back up retrospect in a way. This is a very unique animal that we're doing here from a law standpoint. I'm sure you understand that.
I would argue that it's not unique. Missouri is behind on this. The vast majority of states are doing this. I haven't even mentioned the legislation that's presently active in other states right now. And many states, by the way, Delaware, Hawaii, California, have brought in subsequent revival legislation because they realize the value for their citizens. The only thing I can offer, I haven't seen the attorney's fees on the other side. What we have seen is a certificate whereby before you can file the claim, so we've seen this in quite a few states to where the victim plaintiff has to meet with a psychotherapist or a licensed psychotherapist, psychiatrist, and sort of get a clearance or a rubber stamp that, in fact, there is sufficient evidence in the eyes of that expert to say that this person did experience this abuse.
Okay, so what you're saying is there, in some states, there are some type of, I guess, vetting process or whatever you want to call it within it for something like this here is what you're saying. Okay, all right. Like I said, I'm not against it. I'm just curious when I look at this. I think of, okay, a case gets really old. We end up in a situation where the person's 50, 60, whatever years old. This happened when they were 12 years old. They might have the evidence, they might not. I don't know, bring your claim to court. But I just want to make sure that if we're doing this, that we're looking at it from due process, which we go in there obviously saying that prove your case. And it's like, then if you can't prove your case, then, the other side shouldn't just get drug in there, if that makes sense. Whoever it is.
Understood.
So that's my only comment towards it. So, all right.
Thank you.
Thank you.
Additional questions from the committee. Representative Reuter,
To inquire.
proceed.
Thank you. You mentioned that this type of law has already been passed in several other states. And you mentioned earlier when we were talking privately, you mentioned that there was an impact on the state of Missouri because of some of our surrounding states' legislation. Can you talk a little bit about that? I'd really like the committee to hear that.
Certainly. So for those states that have very weak statute of limitations, again, specifically for child sexual abuse, these are unique torts, right? What we're finding is in other states that have stronger laws, this becomes a safe haven for perpetrators, right? This becomes a place where it's very friendly to perpetrators and not so friendly to children. So we see perpetrators move from unfriendly states to friendly states like Missouri. Did I answer your question?
And would you say that that puts our children at more risk?
100%.
Thank you.
Thank you.
Additional questions? Seeing none, thank you very much for the
Thank you.
testimony. First witness in opposition, please come forward.
Mr. Chairman, members of the committee, my name is Rich Aubuchon. I'm here on behalf of the Missouri Civil Justice Reform Coalition. An advocacy group for due process is one that we like to be part of. And quite frankly, you can't create a vested right like we do here in Missouri on statute of limitations and then take it away. It's like giving a piece of property and then taking it away from you. That's just not how we do business, frankly. Missouri is unique. Missouri has a very unique perspective on statute of limitations, that it does create a vested right. So that's why they're attempting to change the Constitution. It's a pretty drastic measure. Changing our Constitution shouldn't be a second set of statutes. And we've seen that with some approaches that we've seen pass in IPs. Not necessarily a great thing. I'm not here to fearmonger you. I'm telling you that this due process is important. And when you start creating special classes of people, special classes of actions that don't deserve due process, I think we start having to have some introspective around ourselves whether we deserve either. Because we're going to start seeing an erosion of due process for all of us, and I think that's a problem. Now, obviously, these things are aberrant, right? This is a crime. It's an intentional act. It's not something that you see, just because someone hurts one another by accident. It's not like a slip and fall. I forgot to pick something up off the floor and someone fell on it, right? This is an intentional, horrible act. Hold the perpetrator liable. We've advocated for getting rid of the criminal statute of limitations. It was something that we did very, very, outwardly to support that. You want to punish the person, put them in jail. I'm all for it. You want to go after the employer? Wait a second. Were they really part of that enterprise? I mean, that's a discussion here. It's like we're acting like every employer is a bad employer out there. It's not the case. And I'm certain there are some employers that have helped create some environment where a wrongdoer has been allowed to stay and do more terrible things. I'm sure that has happened. The allegations have been made about Kanakuk regarding that. I'm not here to defend Kanakuk. I don't know anything about it, other than the fact that I sent my daughter to Kanakuk once. And the fact is that, when we see something like that, it does make us all mad. It makes us want to, go punish that group, that person. But I also want you to take an advantage that we're talking about doing this for all employers, not just one. And I really wish that we could have a law, quite frankly, that addressed just that one person, that one group out there that was just that bad actor. That's not how it works. And if we start taking due process away from one class of people, what's next? Who's next? It's a question that quite frankly, we shouldn't have the answer to here. Statute of limitations are arbitrary. We've advocated for getting rid of statute of limitations in criminal law. We've done so in Missouri already. And we start looking at things that have financial impacts. Yeah, we're not here to fearmonger you. We're telling you that if you want to have recovery from some of these bad actors, you're going to have insurance, right? because they're not going to be able to pull out cash out of their pocket. And the guy that committed all these terrible acts is in jail for Kanakuk, right? And if that's the case, you still want to make sure that there's insurance to cover, for those victims that are out there. If you create an environment where there is no ability to afford insurance, what's going to happen to the victims? They're not going to be able to recover anyway. And that's not a great environment either. Look, I'm not here to fearmonger. I'm here to set it straight that we feel as though changing the Constitution is a bad thing for this particular instance. We have actually worked to extend our statute of limitations for sexual assault. We've actually worked on language in the Senate already, and we believe that we have a compromise on that language in the Senate to extend the statute of limitations for sexual assault. We believe that going after the employer is the wrong thing. That's fundamental.
Thank you for the testimony. Questions from the committee. Representative Engel.
Hi,
Proceed.
Representative.
Good afternoon.
Afternoon. We're
Okay.
sneaking into the evening here. Real quick.
Yeah. So you're against statute of limitations? You'd like to get rid of them?
We've done. What I'm arguing is that we've done so on the criminal statute.
Okay. So you're fine with getting rid of it on the criminal side, but not the civil side.
That's correct.
Why is that?
For the reasons that I stated on the record, that if you're actually asking for companies and individuals to be liable, and if we're talking about this particular resolution, which is getting rid of the statute of limitations and actually going backwards, that Missouri's law today allows for a vested right, which is a property right, in a statute of limitations that has expired. So it is a property right. It's just like any other property right that we talk about. It's a guarantee. It's protected by our Constitution, state and federal. So if that's the case, then why are we taking that away and replacing it with something new? That's my point.
I mean, I think because these people are being found liable for child sodomy and rape. So, and I think that that's something as a culture and as a civilization, we've decided that we're against that. We've learned throughout the last couple of decades so much about repressed memories and complex PTSD, especially when it occurs during developing brains,
That's a great
and that
point.
folks often, it's entirely normal.
It's a great point that you made.
For children to not disclose for years and years and years.
I totally agree. And in fact, there is case law in the state of Missouri that while the statute of limitations is treated as a matter of law, the fact is that if you have a repressed memory, there is case law in Missouri that it will allow that issue to go to the jury.
Mm-hmm.
And that has been used in the
Right.
state of Missouri to
So
allow
why
them to
wouldn't-
file
why
many
wouldn't
years
we
later,
hold-
decades later.
Why wouldn't we hold the folks who have been protecting these abusers over the course of time? Why would we want to protect them? Because the clock runs out. The crime still occurred. The damage is still there. Why wouldn't we allow survivors the chance to have their day in court, to have those compensatory needs met? If we're saying on the criminal side that we're fine with getting away with the statute of limitations, and by God, I am all for that. Because a crime is a crime no matter when it happens. If you put your hands on a child in this state, you need to be held accountable. And I mean, I think we could go a whole lot further than this personally.
I don't disagree with you on the criminal action. I think I'm trying to make a distinction between an employer generally.
An employer who
And
knows or should have known
but
that
let's-
this was happening.
But let's also make the distinction about an employer who was part of the enterprise. If that was the case, maybe they should be prosecuted criminally as well.
Well, this isn't saying that they're not. This is just saying that they
No.
can also be
But-
held civilly liable.
But you can't also create a function where we have a vested right for a classification of people and then take it away and act as if we're blind to the fact that we've taken away a due process right.
Sure, but we can do that. We can create the special class. We can do
It would
that.
be extremely dangerous for a society, let alone ours, where we tell a certain group and classification of people in our society that they are not entitled to due process.
So
No matter how
the people
aberrant,
being accused
no matter what their
would
race,
be the
origin,
victims.
etc.
Okay, so when you were saying special class, I thought you were talking about the kids. You were talking about the alleged perpetrators.
The alleged perpetrators are also
Got it.
part of a class.
Right.
If
I understand that.
classification of people.
I understand that. I don't know how this, if you don't have a case, if you're not able to make that case in front of court, I mean, why does it matter when it occurs? Does that make sense? Like, so if 10 years, 15 years later, an adult who was a child at the time of the offense now discloses and is able to identify and is able to provide credible testimony, then why does it mean less than it did 10 years before?
Well, if you're focusing on a scenario where that individual had repressed memories,
It doesn't have to be repressed.
well, but I think that's
There's a lot
something
of
that you
reasons,
raised earlier.
but there's a lot of reasons why people do not disclose.
I'm sure there are. No, and I don't discount that. And please don't get in the respect that I'm supporting in any way that type of an environment where someone is harmed and shouldn't be compensated. And frankly, that's something that we all agree upon. And if someone harms another, they should receive compensation for that harm. And I'm not taking that away from anything here. I think that we all believe that an individual who is harmed by another should have the opportunity to have redress. How long does that matter? And quite frankly, what we're talking about here is a very different thing than just seeking redress. We're talking about taking away a property right that was attributed by today's law to a group of people and taking that away so that we can benefit another group of people. And that's at its core.
Right.
That's at its core. And what we're doing is making excuses because of the aberrant nature of how terrible what it is. Mm-hmm.
Yeah.
And if we do that now.
But that is how we write laws. That's why we put penalty enhancers on things, because we decide that when something is, to quote Law and Order SVU,
but that's not
like
a due process
especially
right.
heinous, we are able to address that.
But that's not a due process right, and there's no due process in criminal statutes changing. There is in civil law. But I'm just trying to make that distinction here, and I hope that I can. What I'm trying to do is at least bring to light that if we'd start taking due process away from certain individuals, certain companies, whatever they be, that we are heading down a very dangerous path.
Would they or would they not continue to have their day in court to aid in their own defense and to have due process?
That's procedural due process.
Okay.
And there is a difference.
So how are they losing due process?
There's a substantive due process right as well, which is quite literally, if you were to put your fingers into dirt, that's something you can feel, right? Mm-hmm. But there's also the procedural due process, which is a matter of making sure, like you said, did they get notice of the trial? Did they actually get served with the suit? Were they allowed an opportunity to be heard? Those types of things.
Right.
But you can do retroactive laws on procedural matters in the state of Missouri. You just can't do it on substantive matters. And Missouri's law is very clear from our Supreme Court that a taking away of a substantive right, which is, in this case, a statute of limitations, is a vested right, which is a substantive right. And doing so is a violation of our Constitution. So now we're start talking about, well, let's change the Constitution. That's what this would be. Mm-hmm. And I'm telling you that it was a very dangerous proposition that we start taking away due process for one group of people in exchange for also protecting another group. And I hope that we can appreciate that, because it could be taken to a lot of different areas of this law.
I understand that. I disagree, but thank you.
Thank you, and good questions.
Any other questions from the committee? Representative Meredith.
Hey, Representative.
Evening.
Evening.
Forgive me, I'm dealing with a migraine and didn't really want to engage in this, but can you just...
Still a chance.
You're right.
I'm just trying to be...
No.
Make you feel better. So.
Can you explain what due process you think a business is losing?
Well, I believe that I have.
I'd like to hear it again.
Well, statute of limitations in Missouri is a substantive due process right that is a vested right if it has expired for the statute of limitations. And that's for an individual, for a company, as
Why is that a
individual.
fundamental due process right? I get that it's been described as a legal right. Why is it a fundamental due process right? What about their right to due process goes away?
So due process is different for procedural matters and substantive matters. Substantive matters affect
Substantive due process is different.
Yes, and substantive due process has been applied to statute of limitations in the state of Missouri pursuant to our authority here.
Right. I'm asking you on a more philosophical level. What about it? Due process is about fairness of the process. It's what's due them to make sure that they have had essentially a fair treatment by the law. What is the unfairness involved here? Can you articulate that?
I think I have that it is a substantive due process.
Just because they had it and we take it away.
That's right.
That's
And
what
whether
we
it's
do
a
with
piece of
laws all the time.
But that's what also protects us from other nations as well. The fact that it separates us from other nations as well, that we have a constitution that protects us as individuals.
But we change our constitution.
We do change our constitution, and this is an approach to do so as well. Not the federal constitution that much. We certainly have done so in the state of Missouri to provide more rights and privileges for
And isn't this
for people.
providing more rights to victims of childhood sexual abuse?
You are also focusing on the fact that it only attributes to the rights of individuals who've been harmed. And what I'm telling you is that in Missouri, we have recognized rights for other parties, whether they be plaintiff or defendant.
But isn't it reasonable to say that, as was just discussed, with childhood sexual abuse, there are a whole lot of very unique factors involved that make it where, if we want them to be able to access justice, it actually does have to be treated differently because of all of the reasons that historically and societally, those cases don't come out until past the timeline that usually applies to other types of crime.
They're good questions, and I believe that what you're arguing, though, is the lesser of two evils. And what you're trying to do is protect.
I don't see the evil in this.
Well,
That's what I'm struggling to see. Where is the evil?
Because of the fact that you're taking away a due process right that is substantive under the state of Missouri.
From someone that helped cover up childhood sexual abuse, I don't see that being an evil. It's allowing justice.
Representative, you're assuming that individual was the one that caused wrong.
If it's proven in court. If not, they aren't going to be liable.
Representative, I'm trying to explain the distinction between an individual that did commit and an individual that was accused of committing. And what I'm trying to say is, for the state of Missouri to have a substantive due right in an employer, not all employers are bad, right?
Sure, that has to be proven in court.
Not all employers are bad. And if we're talking about a minute distinction of what 0.02% of cases that were out there, the fact is that we're also telling all employers they have to have, in perpetuity and retroactivity, the ability to pay for things that they didn't even know about. And that I'm trying to bring to the light to the committee that if we're talking about taking away someone's life, liberty, their money, their business, we have to take that very seriously.
I understand taking it seriously, but I also think we have to take seriously the need for justice and accountability. And, you've mentioned you get that when it comes to a criminal. Well, the person that is liable criminally for this, you're okay with them being punished later down the road, but the point of these laws is to hold accountable someone else who's also responsible for this same atrocious act. If they weren't responsible, they wouldn't be held liable. And so being able to say part of justice, part of accountability for these atrocious acts is making sure that all of the parties responsible can be held liable when truth comes to light. Right?
Senator, I don't think I'll ever be able to convince you of this point. But the fact is that under our laws today, a criminal statute can change, and then there is no vested right in the change. Under Missouri's law today, there is a vested right for the expiration of a statute of limitations.
Which is the only reason this has to be constitutional, correct?
And that would assume that we still don't run into problems with ex post facto laws here. And that is not a settled issue here. Other states are very different in that regard. Other states have held that it is not. I don't believe that will necessarily be the case here. I'm just telling us that we need to be very cautious about taking away due process, which is a substantive
Yeah,
right here.
the idea of calling this taking away due process is just such a stretch to me.
That's why I say you'll never be able to convince you of it.
You said you weren't here to fearmonger, but then suggested that we won't have childcares or schools
I have said
because
that it
they
will be very
can't afford
expensive.
the insurance.
I have said it would be very
How
expensive.
much do you think, in other states, has this happened?
I have seen and reported on that in California there have been instances where insurance companies stopped writing these policies.
Where?
California.
No, so, I mean, you're saying that there are no insurance policies for childcares or schools now?
They have exempted those acts from the insurance policies.
Okay. Has it closed schools and daycares?
No, it hasn't, because they're not responsible for that coverage.
Okay, so maybe they don't have insurance coverage for it, but that doesn't
may
prevent them
happen.
from being sued and liable with
No,
the assets they do have, right?
That doesn't prevent them from being sued and being liable.
Okay, well, that doesn't sound that atrocious.
Look,
I mean, that's
I'm not
between an
trying to
insurance
fearmonger
company
you.
and the,
I'm just trying to tell you that will happen.
okay. If the point here is we want to make sure that there's accountability for perpetrators and those responsible, that doesn't sound like it prevents that.
Well, if you're talking about a scenario where there are multiple people and you want to have the ability to recover, certainly you need to have insurance to be part of that, right?
No, not if it's that or they don't have an option of recovering at all because of a an arbitrary statute of limitations.
So a person past the age of 31 under today's law would not be able to file a case unless they had a repressed memory argument and were able to argue that it was a late
But as we already
memory.
talked about, there are a whole lot of other reasons it may have taken past 31 to be able
It may have.
to process this and
But that
file a claim.
in and of itself is not an end. Just because the statute of limitations period is out there, it doesn't mean that they couldn't file. It
Well-
just then becomes a question of fact.
But then they have to have one specific reason to get
true.
around the statute of
That's true.
limitations. And the point we're making is there are a whole lot of reasons that justice warrants them getting around the statute of limitations.
That is a point that has been made.
Okay. That's good enough. Thanks.
Any other questions from the committee? Seeing none, thank you for
Thank
the
you.
testimony. Next witness in support, please come forward.
Elizabeth Phillips from Dallas, Texas. Thank you, Chair Riley, for inviting this hearing on House Joint Resolution 129, which proposes a constitutional amendment to allow child sexual abuse and trafficking survivors fair access to Missouri's civil courts. Thank you, Representative Seitz, for stepping up to author this resolution and for leading in the House on this issue now for 2 sessions. It means a lot to Kanakuk survivors that this originated from a Taney County legislator. To the committee, I'm here today to speak on behalf of my late brother, Trey Carlock. Trey was silenced to his grave by Kanakuk Ministries based in Taney County, Missouri, the greater Branson area. Kanakuk claims to have hosted 500,000 children at their multiple camps in the Ozarks, yet their decades-long history of child sexual abuse was only recently exposed to the public. My family chose to name Kanakuk abuse in Trey's Dallas Morning News obituary in 2019. And since then, we have heard from countless other victims and victim families. Almost 5 years later, the survivor community affiliated with Kanakuk abuse is now connected and knows of nearly 200 victims spanning from the 1950s to today, with allegations against 60 unique perpetrators. Most are still at large due to Missouri's antiquated statute of limitations. We're hopeful that this legislature wants to do something about that. This isn't one bad guy who was put away, problem solved, but let's talk about the example of one bad guy. My brother was abused by Kanakuk Camp's executive and super predator Pete Newman, who remains in prison for 2 life terms plus 30 years here in Jefferson City. Newman is one of the most prolific super predators in modern American history, with the prosecutor estimating a victim count in the hundreds and clinical experts saying thousands. We came to summer camp in Missouri and we left with lifelong trauma. To be clear, Pete was not the only one who abused my brother. Trey was abused again by Kanakuk and its agents, who harassed and gaslighted him in a re-traumatizing legal process that ended in a settlement achieved by fraud, which also included a restrictive NDA. Not just his innocence, but his voice was stolen too. And he is sadly one of many John Does with this story who can't speak for themselves because of the NDAs Kanakuk and insurers put them under. Since Missouri's current statute of limitations requires victims of child sexual abuse to file action against a direct perpetrator by the age of 31 and a liable institution by the age of 26, victims are forced to relive their nightmares when they're just trying to survive and heal. The male brain isn't even fully formed until the age of 25, and you're requiring them to file by 26. So Trey was prematurely forced to file by the law, and he sued Newman, Kanakuk, and other third-party defendants, like an insurance company that was in on the fraud, to afford lifelong treatment, which is what many child sexual abuse survivors need. Just putting a bad guy away doesn't cover those lifelong costs. So the cost can land on culpable institutions through civil remedies, or it can land on taxpayers and victim families. That's the choice. Trey tried to heal, but the damage was insurmountable, and I lost my little brother when he was 28. Trey's death of despair is one of 16 affiliated with Kanakuk abuse known to date. The devastation is incalculable, and this is just me talking about one corrupt institution in Missouri. I don't need to name the others you've read about in the news. And good employers don't have anything to worry about with this. Sadly, more has come to light since my brother's death that we didn't know. Back to a corrupt employer, such as how Kanakuk knew of Newman's felonious behavior at least a decade before he confessed to it, and that there are scores of Kanakuk-affiliated predators other than Newman whose victims are well out of criminal and civil statute, so their only recourse has been to courageously share their stories with investigative reporters in hopes of sparing more children from harm. That's the goal, not money. It's sparing others from this harm. The stories they've shared with media outlets such as the Branson Tri-Lakes News, St. Louis Public Radio, and the Springfield News Leader unveil that abusers were shuffled around and allowed to continue their employment at Kanakuk-affiliated ministries long after camp abuse was reported. Those include K-Life, Kids Across America, and others that operate in your state. These criminals would have been stopped, and hear this, still can be stopped, if only their victims were not barred from Missouri's civil courts. The problem persists until this legislature takes action. You've now heard a national expert testify that the average age of disclosure for child sex abuse victims is between 50 and 70 years old. You're aware that there's a national movement to match policy to research through constitutional amendments that allow for retroactivity, such as HJR 129. This is not a novel idea. Your neighbor, Arkansas, just extended its 2-year revival window for another 2 years this session because they want victims to be able to hold child predators to account in civil courts at any age, and that's what's in the public's best interest. So, Missouri, I'm here from Texas to ask you to join the movement. It's time to stop the clock for child sexual abuse survivors. Don't rush them into civil litigation like my brother. A short statute of limitations can be lethal, as my family knows, and another form of rape. I hope you can also see that this gross systemic injustice is making Missouri a sanctuary state for pedophiles. Bad actors intentionally operate where they'll have the least liability and regulation, while victims never imagine they're on a deadline, age of 26, to seek legal recourse for the unimaginable they've endured. But you have power, they do not. You have the power to propose an amendment of your state constitution, like over 20 states have done, to make Missouri safer for kids. And that's what House Joint Resolution 129 is really about. Addressing the backlog of hidden predators now and allowing victims the time to heal on their own terms moving forward. This piece of legislation is a critical step forward for child protection. I'll leave you with the reminder that April is Child Abuse Prevention Month. We're calling on you to prioritize the protection of kids in a way only you can. Remember, Trey, let your courts hear these cases Until then, Missouri is not safe for children. Thank you. I'm happy to take any questions.
Thank you for your testimony. Any questions from the committee? Seeing none, thank you again. Appreciate it. Next witness in opposition, please come forward.
Mr. Chair, members of the committee, Michael Henderson for the Missouri Insurance Coalition, opposed to this legislation for many of the same reasons that Mr. Abishan has already outlined, not the least of which the Supreme Court in this state has already held that when a statute of limitations has expired, a plaintiff's claim is barred, that the defendant does have a vested substantive right to be free from suit. Representative Meredith, you asked, what's the substantive right they're losing? It's the right to be free from suit. Why do they have that right in the first place? It's because since 1820, Missouri has had in its constitution, in all four of its constitutions, I believe we're on our fourth now since 1945, that no ex post facto or retrospective laws shall be enacted in this state. The reasons are clear. I think you go back to some of the constitutions from the original 13 colonies. They say no retrospective laws shall be enacted because, and they spell it right out in their constitution, retrospective laws are injurious. They are oppressive. They are unjust to those who would rely on the certainty of their states or their federal government's laws to go about relying on the rule of law as has been set forth, by their governments. So that's the right that's being affected. I know, Representative Engel, you pointed out, why shouldn't an individual have their ability to make their case? If they can't make their case, they can't make their case. I think this gets to a point that Representative Hicks raised. If you go back to a case from the 70s or the 80s, and allegations are now being brought not only against a perpetrator, but against a business. And I'm not talking about a Kanakuk who's conspired to protect individuals. As Mr. Abishan pointed out, that's abhorrent. But I think in a lot of instances, you are going to have not only allegations against a perpetrator, but also a business, a non-perpetrator. It could just be as simple as negligent hiring of an individual, negligent supervision. Part of that reason, just to be frank, is because the business may have had insurance. And with insurance comes, as has already been testified to those who support this bill, compensation for possible victims. But I think just as important as allowing an individual maybe to have his or her day in court, also businesses, I think, have the right to put on a defense of their case. And if we're talking about allegations going back to the 70s or 80s, what ability do they have to provide a defense on that, especially if documents have been, gotten rid of under document retention policies, maybe in reliance on statute of limitations on claims that may have been brought that have now expired. How do we know insurance policies that were issued to a business in the 70s and 80s, to the extent they can be identified? Were these types of claims even in that time period contemplating these sorts of claims? One. Two, were they underwritten with an understanding of the laws of the day, including statute of limitations? These are all questions that get raised when in the present day we are passing retrospective laws on statute of limitations that have passed. I think there's a reason why for the past 224 years this state has had a constitutional protection against retrospective laws that has not been changed, and that's why we oppose this legislation. Happy to answer any questions.
Thank you for the testimony. Any questions from the committee? Representative Engel. Proceed.
Good evening.
Good evening.
Okay. Have we made changes in statute of limitations in any of our constitutions?
Have we made
In
changes?
law, yeah. Have we changed our statute of limitations?
Certainly.
Yeah. Okay. And have we gotten rid of statute of limitations for certain crimes, offenses?
I believe we have for crimes, yes.
Okay. So sounds like we've We've done some of that retroactive justice stuff in the past, right? I'm not an attorney, but,
I would have to defer to the witness, the first witness that came up in support, and to Mr. Abishan that have worked on removing the statute of limitations for criminal actions. I
Right.
believe that was in 2018.
Right.
That may have been retrospective. I don't know that off the top of my head.
So-
To the extent that was, but to your point, constitutionally, removing statute of limitations retroactively is not allowed, absent a change to the Constitution.
so that's what we're trying to do here.
Yes. And that's why my testimony is we're opposed to changing the Constitution for the reasons that I've stated on the record.
Okay. You also said that it placed an undue burden on the defense as time has gone by to aid in their own defense. Okay. And I'm legitimately asking this. Is the onus on the defense or on the plaintiff in civil court?
Certainly, the plaintiff would have the burden to make his or her case.
Okay. Thank you, Mr. Chair.
Additional questions, Representative Meredith.
Thanks, to inquire.
Proceed.
I'm curious, it was mentioned earlier, there was a slippery slope argument made that if we allow this in this context and create a special class, we're opening the door to lots of others. Do you share that concern?
Yeah, I do.
Okay. I will tell you, one of the first things I learned in 1L year was about the problems logically with slippery slope arguments. And that is, we're not really talking about those hypothetical others. We're talking about a very specific situation, which is child sexual abuse.
Sure.
We already treat this category as differently than everything else, don't we?
In what regard?
In our criminal laws?
I think against the perpetrators, we probably do.
Yeah. Like, they have to register for life. They get tracked. They have rules about where they can live, things like that, right?
Yeah, and that is true. I believe there has been case law on this, though. That only applies to those who would plead guilty after the date of those laws being enacted, right? So those that may have fallen under those before those laws were passed, I think there is some case law out there that to say it cannot retrospectively go back and apply to those.
Yeah, no, I think that might be true, but the point is we treat them differently. We have created a special class, and that is perpetrators of child sexual abuse. Wouldn't the people responsible for that child sexual abuse include more than the people that directly committed the acts?
I think it would depend on case-by-case basis.
Well, we've heard about the camp in Missouri. It sounds like there were a lot of people responsible, even if there was only one perpetrator of each act, right?
Sure.
So wouldn't it make sense that they would also be treated as a special class that maybe we want to treat differently and remedy something that has been wrong for 200 years in our history?
Yeah, and I think, to go back to and echo what Mr. Abishan has mentioned, I think the difficulty is trying to carve out a law that would hold the Kannakucks, the Boy Scouts, Catholic Church, these institutions that we know of that have had
or the ones we don't.
Instances of this. And, your everyday businesses, most of whom are not engaged in grand conspiracies of this regard.
And probably wouldn't be at particularly high risk of this either.
Well, I think especially when you look at the language of the statute, when it says tortious actions that caused this to occur, I think that's very broad, right?
Yeah.
So I think, as I already mentioned, I think it's inevitable that if these lawsuits from retrospective years gone by are filed against perpetrators, likely you're going to have businesses of all sorts at least getting lawsuits filed against them. And while certainly it's the plaintiff's, responsibility to make his or her case, you still have to put up a defense. That costs time and money.
Yeah.
You may not be able to put up that defense 40, 50 years later on a claim that maybe you didn't even know about.
Yeah. It's hard to me to imagine putting a price tag on this aspect of justice, especially if they're still getting their day in court and have the ability to not be found liable if they aren't. I'm curious, I'm pretty sure Mr. Abishan said that they've supported extending or eliminating the criminal statute of limitations and doing so retroactively or retrospectively. Is that your position too? You don't have a problem with that?
My position is, when it comes to perpetrators, we have no position on that. And so
Yeah.
if it were to extend, that's fine. Again, this, my testimony pertains to non-perpetrators.
Yeah, I guess I struggle with that idea of non-perpetrators, because the point is, if they caused it, they are perpetrators.
Well, I think certainly when you talk about like a Kanakuk, where their actions have gone to such a degree and been so egregious, they may be perpetrators themselves, right?
Well,
But,
I think it's fair to argue that even if they just were grossly negligent in the standards they had for making sure that the kids under their care were safe, that maybe they're also perpetrators. And that if we want justice to be available to kids who are now adults, we have to change this. It's our duty to change this for the sake of justice. Of holding perpetrators liable, just as holding the individual that committed the act liable criminally. That's an important part of it, but justice is a lot more than throwing someone in jail. Justice is changing a system. Justice is holding institutions accountable that are at fault. Justice is some monetary damages to either change behavior, change systems, or just pay the person for the harm that they've faced and the costs that they've faced for the rest of their life. That all seems like part of the same equation, doesn't it?
I think to your point, if you're going to consider them perpetrators, then I think there would be no need to have separate language,
Well, except you're talking about civil liability, not just criminal.
Sure, I'm talking about civil liability.
But isn't that what we're talking about here? Civil liability versus criminal liability?
Right.
Shouldn't it apply in both cases? It feels like what I'm hearing is we don't mind looking retroactive against a criminal that committed an act who's potentially going to be facing life in prison and more.
Well, what I'm saying is...
But we do have a problem if we're talking about the dollars and the money of a business who's also responsible for this. Now we're concerned that that's not fair because it's their fundamental right. And I'm sorry, but I think right to not be incarcerated is actually more significant than right to have to not pay damages for something you did. Like, that should be the least of our concerns in the constitutionality of retroactive. I mean, when we talk about ex post facto laws changing something that was legal and saying it's now illegal from when you did it when it was legal, I completely agree. We can't lock somebody up because they did something that at the time they had an understanding was legal. But to say, hey, turns out you should have to pay something for this thing that if they'd sued you 5 years earlier, you would have had to pay for, that doesn't really seem like we're fundamentally attacking somebody's rights.
Well, can I respond
Yeah.
to that? I think, a couple points on that. I think, again, it's not all about money. I think you have a right to put on a defense of
And they'd still be able to do that.
And I understand your point. But
I keep hearing that, but they will get to put on their defense. And I'm really tired of the implication that suddenly they're just going to be unable to defend themselves in court because we've taken away their right to do so. No, they still get their day in court, right?
Well, to the extent that...
You just don't want the plaintiffs to get their day in court.
No. To the extent evidence from 40, 50 years ago no longer exists.
Again,
how
though,
can you put
who
on a
has to
defense?
prove their case?
And
if the evidence doesn't exist, then the plaintiff's not going to be able to prove their case. If the evidence is there, then they should be able to try and rebut it.
I would disagree. I think the simple fact that the allegation is made, you and I know how the legal system works. I think that exposes a business to liability. I think, to your point, you don't think we're taking away a right. The Supreme Court has said you're taking away a right. Why? I know you mentioned the ex post facto laws, freedom to be free from something you committed and not being... The founders of this state had said not only ex post facto laws, but very expressly say ex post facto and retrospective.
Yeah.
To prevent.
Well, the founders of this state got a lot of things wrong, didn't they?
Sure, but
Yeah, I mean, there was a lot of justice they missed, right? So we amend the Constitution if we see a hole, a gap, where justice is not being allowed by our Constitution. It sure strikes me that justice for child sexual abuse might be one of those instances where we need to update for what we know now. Thanks.
Thank you.
Additional questions from the committee? Seeing none, thank
you.
you for the testimony. Next witness in support, please come forward.
I'll keep this brief. 4 minutes, that's all it takes. I timed it. Mr. Chairman and members of the committee, thank you for this opportunity to speak. I am Dr. Kevin McGraw, and I have owned and operated my dental practice in St. Charles, Missouri for the past 42 years. I graduated from Melville High School in St. Louis. I attended St. Louis University and got my bachelor's degree and went on to UMKC School of Dentistry where I got my doctorate. My wife and I have been married for 45 years, and we have 2 daughters and 3 grandchildren. This is my wife, Vicki. I'm here today to ask your support for this bill. We all know that some people do bad things, and if we don't hold them accountable, they and others will continue to do bad things, and society will suffer. And you, ladies and gentlemen, carry the burden of refining the laws that protect us all. In 2017, you all did a very honorable and just thing by removing the statute of limitations for all sex crimes from that time forward. Our state constitution prevented you from making it retroactive. So today, all victims of sexual abuse prior to 2018 have to abide by the statute of limitations that was in effect at the time of the crime, which for the most part over the last 50 years has been a mere 3 years. Now I'm going to tell you why that law needs to be changed. And one thing I want to clear up, ex post facto, federal law prohibits anyone from changing the criminal law retroactively, but it doesn't prohibit changing civil law retroactively. In my research, I discovered a very credible study, which you've already heard my colleagues talk to you about, which found that the average age that a victim of sex abuse talks to anyone about what happened to them is somewhere in the early 50s. So if you do the math and you say, okay, average age of an abused victim, let's say, is 12 years old, that's 40 years before they say anything. And there are various reasons for that, as you've all pointed out. Shame, humiliation, and most women think they are responsible in some way for it, and they don't want to tell anyone. So I confirmed this with a psychologist that I know, Dr. David Klein, who added that many victims never tell anyone, and they take the secret with them to the grave, as it is too painful and shameful to recall the memory. Last year, my wife told me about something that happened to her 47 years ago, before we were married. She'd kept it a secret that long, which I thought was odd until I discovered the study I just cited. I then realized that she fell comfortably within the bell curve of sexual abuse victims with the average of 40 years before telling anyone about it. A young man whom she was dating in college, and she had dated him several times and thought she could trust him, asked her if she wanted to go see his grandmother's farm in St. Charles County. She went along, and there he sexually assaulted her. He didn't kill her, which was nice, but he took her home and subsequently told her he didn't want to see her again. After she told me what happened to her, I researched the statute of limitations for sex crimes in the state of Missouri and discovered that there was no longer a statute of limitations for rape or sodomy. So I urged her to report it to the St. Charles County Police, which she did. A few days later, we received a call from the prosecuting attorney informing us that the law pertained only to crimes going forward from 2018 and that the statute of limitations for us had unfortunately expired. That's when my wife and I joined this crusade and found that there were many others who had been fighting this battle as well. We're not involved in this endeavor simply for our own interest, but also for the thousands of victims who have no voice, as they have no avenue for recourse. Today, we're not asking you to make that change. We're only asking you to approve a bill that would allow the people of Missouri to vote on that constitutional amendment to remove the civil statute of limitations retroactively so that all victims of a sexual assault have an avenue for recourse. Please vote yes and pass this bill so that the people of Missouri can decide whether or not to continue protecting sexual assault perpetrators or to support the victims of sexual assault by giving them the ability to legally pursue their offenders. That's all.
Thank you very much for the testimony. Any questions from the committee? Seeing none, thank you again. Are there any other witnesses here in opposition? Seeing no witnesses in opposition, next witness in support, please come forward.
Hi, good evening. Jessica Seitz. I'm the Executive Director of the Missouri Network Against Child Abuse, formerly known as Missouri Kids First. I won't repeat what some of the folks before me said, but I want to voice our agency's strong support of this legislation. We represent the state's child advocacy centers who serve about 10,000 children who are victims of abuse each year. Last year, about 6,000 of those were victims of sexual abuse. It happens in our state. But so many children do not come forward until well into adulthood. The research supports that. So you've heard about the lifelong impacts of childhood sexual abuse. It lasts, the harm and the trauma lasts a lifetime. But also about how states across the country are tackling this to correct the wrongs of our outdated laws now that we know more about this issue. And so, including our neighbor down in Arkansas, just changed their law last year. Can't be behind Arkansas. So our agency sees this as an important tool to helping survivors of childhood sexual abuse further achieve and find justice and healing. We've revised the criminal statute of limitations. I was very proud to work on that in 2018. But yes, that cannot be applied retroactively but also prison criminal conviction is only one part of the healing. Healing from sexual trauma is expensive. It incurs a cost on the individual, the family, and on society. And it's our position that those costs should be shared. And so right now our law prohibits that. It limits that. And we'd love you to consider this legislation. Thank you.
Thank you for the testimony. Any questions from the committee? Representative Meredith, proceed.
Thanks. So that's a helpful point, actually, just to circle back to other states have done this.
Right.
Retroactively.
Yeah, on the civil side, yes.
On the civil side.
Yeah.
Have any done it on the criminal side?
That's against the U.S. Constitution.
The statute of limitations portion on the criminal side?
Criminal. To apply, so for a criminal, I'm not a lawyer, so don't. But
I'm barely one in this context.
Okay. So on the criminal side, you cannot retroactively. So once somebody has committed a crime. So when we changed the law in 2018, that only applied to crimes that were committed after 2018. So if you committed the crime in 2010, and it brought up, you would be subject to whatever the law was in 2010.
For the statute of limitations too, not just whether it was legal or not.
Right. So on the criminal, and so it is against the U.S. Constitution.
Again, because there's probably a higher threshold for locking somebody up than for making someone pay for the cost of their harm.
Absolutely. That was a foundation, yes.
Which seems like a reasonable, fundamental American thing to me, that concept that these two have different thresholds. So other states have retroactively done the civil liability statute of limitations.
Yes.
And have those been challenged in court?
I'm probably not the best, I mean, as far as have people filed, or filed.
To your knowledge, have any of them been struck down?
To my knowledge,
To
no.
your knowledge, no.
But there's,
Maybe
Catherine may be able to, she's much
Maybe
more
one has.
knowledgeable of the national scope of this, so I'm not, to
Okay.
my knowledge, no.
I'm going to want to find out more about
Yeah.
this because I'm
Sure.
curious if it was struck down, if it was a statute or if it was constitutional amendment, and if it was struck down under state grounds or federal grounds, because I do think that distinction matters.
We can get you an answer to that.
Cool.
Yeah.
Again, because if it's on state grounds that it was struck down, well, if we're amending the Constitution to do this, I'm significantly less worried about that because that's our state.
Let's go.
So, okay, thank you. I'll try and find that out.
Absolutely, yeah, we will get you that answer.
Any other questions from the committee? Representative Reuter,
To inquire?
proceed.
So I appreciate you bringing forward some of these numbers of people, historically that have been abused per year in Missouri. Do you know what, with perpetrators, they don't usually just do this once, right?
No. No. It is, no, it is not usually one time. That I think, it's been a little while since I've looked at that most recent research, but no, perpetrators of child sexual abuse in particular, it's multiple times.
So this is not just, we're not talking about just one victim per perpetrator. We're talking about numerous, sometimes hundreds.
Yes, absolutely, especially when in some of the cases that were referred to before, in the case of Kanakuk, in the Catholic Church, and even in Missouri, the Catholic Church, Boy Scouts, some institutions, yes, there's been hundreds.
Now, I haven't studied these cases, but it seems to me that there may be something in their files or something in their memory that they found the employee had some questionable behavior with one of their children in their parish or in their care, and then they didn't do anything, and then the next one comes up maybe 5 years later, maybe 3 years later, maybe 10 years later, and it's treated the same way.
Absolutely. My organization has worked over the years. It has happened in schools where a complaint will come up only to find out that this school professional has been from district to district to district, even just neighboring districts. That constantly. And at my centers that serve kids of child sexual abuse, it is incredibly common that once a case has come to the child, like the child has disclosed, to find out past crimes. Like that this individual was employed at multiple child serving organizations before, and for decades, and only one now has come to light. So
would it seem that having a change like this in the Constitution would probably encourage employers to be more careful in terms of who they hire, background checks, and supervision?
Yeah, absolutely. We think that this law is just one step, but it's also, I think, can encourage, so it's our organization's position, and we do it with programming, that it encourages folks to have their policies and HR policies and practices in order. So if you want to have certain types of insurance coverage, right, it incentivizes you, it's just like health, it incentivizes you to have increased background checks if you want your insurance coverage, you have good practices, child protection, child safety. It's going to require an organization that serves kids to have better child protection policies in place. So this is both a way to have victims who've already been abused healing, but in our opinion, it's actually a prevention tool as well. So did that answer your question? I just go on a platform there. So prevention.
Any other questions from the committee? Seeing none, thank you for the testimony. Next witness in support, please come forward.
Thank you very much, Mr. Chairman, members of the committee. My name is Arnie C. A.C. Dienoff, State Public Advocate, and I'm in favor of HJR 129 and allowing the people of Missouri to amend our Constitution. This was needed decades ago. We need to extinguish and rid Missouri of all bad predators of sexual abuses and child sexual abuse. There is a person in my neighborhood who's in his 30s, and he has preyed on children upon children upon children. He's preyed on at least 6 families in which he was caught. The city prosecutor of the city of O'Fallon amended those sexual crime charges to illegal parking or littering. It was a disgrace to the neighborhood, a disgrace to the community. The city prosecutor is now a St. Charles County Associate Circuit Judge, and who is now on the ballot in November unopposed. And that's a shameful cry that he amended sex crimes against these children down to littering and illegal parking. It's a shame. And now this person is in jail due to an unrelated DUI offense in which he hurt somebody in a car accident in the Bridgeton area. Damage is done to young children at least 6 times, but how many times has he done it and not got caught? We need to get rid of the statute of limitations on sexual offenses in our valued and great state constitution. You know, it really angers me that our system doesn't take this more seriously and have more harsh penalties for the crime. It took me 6 years to work on this case and get this person finally on the sex offender list because the prosecutor in O'Fallon amended the charges that he avoided the sex crime list, and families didn't have a fighting chance to know that he was a sex offender. I do not believe that you can reform or fix a sex offender who's done sex crimes in the past. The cases that I know about, the offender reoffends time after time after time. Victims or young ages will have mental anguish and problems for decades, if you've heard testimony, and I won't go over that again. We need to remove the state statute of limitations and allow Missourians the right to answer a question in our state constitution. There needs to be accountability and responsibility of these sex crime offenders. There's no excuse. In my opinion, the city of O'Fallon, St. Charles County 11th Judicial Circuit Court, the police department, law enforcement officers failed at least 6 families and countless other families in which this individual was not caught. My heart goes out to the community because once this person is released from jail on the alcohol offense, I'm afraid for other children that this person will reoffend. For those reasons, I highly support HJR 129. Let's get this on the governor's desk and let's put this to a vote of the people this coming November. Let's get more people at the November election rather than the August election to vote and change our state constitution. Thank you, Mr. Chairman.
Thank you for the testimony. Any questions from the committee? Seeing none, thank you again. Next witness in support, please come forward. Seeing no other witnesses in support, is there anyone here to testify for informational purposes only? Seeing none, that will conclude the public hearing on House Joint Resolution 129 and will conclude our meeting on general laws tonight. We are adjourned.